All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court's now in the session. Please come to order.
Morning, everyone. Welcome to the District of Columbia Court of Appeals remote oral arguments. We have 3 cases on today's calendar. We'll turn to the first, which is Quaranta versus DC Department of Employment Services, number 19AA1112. Mr. Boscolo.
Good morning, Your Honors. Benjamin Boscolo for Mr. Quaranta. This is a very simple question, and I suspect I will not use all of my time, but I'd like to reserve 3 minutes for rebuttal. Mr. Quaranta has a work-related concussion and an optic nerve injury. The history of this case is well known to this court, so I'm not going to recite it here other than to say that his claim for permanent partial disability benefits was denied and affirmed at all levels years ago. Within the 3-year statutory period, that condition deteriorated, and he sought additional benefits for a change in condition. And the changed condition was not for any permanent partial disability. And although it appears to Mr. Quaranta that the agency thinks he's trying to relitigate the issue of whether his retirement constituted a voluntary limitation of income, that's simply not the case. His claim initially in 2017 was for permanent and partial disability. The claim that he sought, the benefits that he seeks now are for temporary and total. The issue that's before the court is very narrow, and that's
Can I ask you, Mr. Boscolo, is he also seeking medical benefits? Is that disputed, or is that an undisputed feature that the employer or intervener are willing to pay medical benefits, and the issue is all about wage loss benefits, or are they both in dispute to your knowledge?
Much as I'd like to speak for Ms. Tarachi, which I generally do, I'm not going to answer that question. I don't believe there's a significant dispute about his entitlement to ongoing medical benefits. It's simply the period of temporary and total disability during the recuperative period. And so we have this very narrow issue, which I have clearly done a poor job of explaining to both the administrative law judge and the CRB.
Can I ask you, I'm sorry to interrupt again, but to follow up with your question. So are you saying that you're not suggesting that is he seeking benefits as of right now, or is his point anticipatory in the sense that he needs medical treatment for his condition, and once he has the treatment, there will be an affiliated subsequent period where he can't work because he's recuperating, or both? That's
it, Your Honor. I couldn't say it better, so I'm not going to try to. And I think, I always think of this Snipes hearing as sort of like whether or not there's enough evidence to proceed with an indictment, right? It's just this basic, is there something here? I'm not saying that Mr. Quaranta will win this period of temporary and total disability. The only issue before the ALJ initially and the CRB was whether or not there was reason to believe that a change in condition had occurred. And it's not the change of the injury, it's the change of the disabling effects, right? And so the claim that had been denied was for permanent disability. The claim that had been denied was for partial disability. The claim that's being put forth is for temporary disability and for total disability. And for the life of Mr. Quaranta, he finds it hard to understand why when you have a period of temporary and total disability, that doesn't at least raise an issue of whether or not there's been a change in condition. Because that's really the question here. Is there reason to believe? And so the proffer was—
I want to make sure, because you were complimentary to my question, which I appreciate, but I want to make sure I understand your answer to it. Are you saying that, are you saying he is temporarily disabled right now?
No,
because he's got medical care. So got it. So it's just so it seems like it's a hard, you'll know far more than I do about how practically to litigate workers' comp claims, but it seems hard how is the CRB or the NALJ in the first instance supposed to figure out ahead of the procedure whether it will lead to disability and for how long? Or is that ordinary that you say, look, I know that my client is going to need a treatment, and I predict that it will cause disability temporarily, and so I want to go in now, and I want to get the ALJ to rule that is going to happen? Or is it more typical that you wait until you have the procedure and then you go in, you say, I've had the procedure and now my client can't work, and I want you to, give me my client disability, temporary disability benefits during the period of recuperation?
The honest answer to that question, Your Honor, is it happens both ways. It is certainly not uncommon in the world of workers' compensation for a party to say, I'm going to get this surgical procedure and I want temporary total disability benefits during the recuperative period, which is undetermined depending on how well the procedure goes, how tough the injured worker is. Sometimes it's 6 days, sometimes it's 6 weeks, sometimes it's 6 months, sometimes it's 6 years. I don't think that would be the case with Mr. Quaranta, but if that were the concern of the ALJ, that's really an issue of evidence that he didn't prove that there was going to be a period of temporary disability afterwards. The real problem here is I proffered that's what he was going to say. The CRB said, we accept the proffer, but it was harmless error. Well, if the proffer was that he was going to be temporarily and totally disabled, and then
I just want to pause right there. The way I read the CRB's decision was they accept the proffer that his condition is worsened, and that the ALJ erred in ignoring the proffer that was made. I don't recall the CRB saying quite the theory that you're floating now, which is we accept the proffer that he's going to be completely disabled by a procedure that he's entitled to. And I wondered, just to go back and piggyback on Judge McLeese's question, I've had this question every time I read these briefs: where is the wage loss? It hasn't happened yet. You're seeking an anticipatory wage loss, and what under the statute entitles you to do that?
Because the wage loss is a direct result of a medical care that has its
it might be
genesis in the employment.
I mean, it might end up being. I just wonder. I guess my question is, what in the statute envisions anticipatory awards of wage loss benefits that have yet to occur?
If you're asking me for, I can tell you specifically in the statute, it does not say the ALJ has authority to award temporary total disability benefits to the president continuing, but that's generally what they do, and virtually every order anticipates ongoing disability. And so the honest answer is, does the statute specifically say that the ALJ can or cannot do that? It does not. Common practice is the benefits are to president continuing for as long as the disability lists. And if we take this—
Now that strikes me as a little bit different. I take your point. I've seen plenty of orders that are continuing, and in that sense are predicting ongoing future wage loss. So that is, you're right, that's a commonplace.
And this is also
orders, but are there orders where no wage loss has yet occurred, and it's just predictive that wage loss will occur? So that it's not to present and past to a degree, to the present and continuing, but there's no past, there's no present. It's all future. Are there orders that are like that you're familiar with, or that?
Absolutely, all the time. Now, listen, Mr. Quaranta, I don't want Mr. Quaranta to be treated differently than any other employee because of who he is or what he does or how much he earns. It's quite common that when a doctor says you need this surgery and you're going to be laid up for some period of time, that an injured worker says, if I'm not going to be paid, I can't get it done. I got bills to pay and I got, families to take care of. And so this is not uncommon at all in the world of workers' compensation, where whether or not the disability that follows a surgical procedure is going to be paid is one of the facts that an injured worker considers when they decide whether or not to actually have the procedure or just live with it. So yes, absolutely happens all the time in every jurisdiction where I practice. And this is no different. And listen, these are all questions of fact that should be supported by a record or not a record. We're really at the question about whether or not there was enough here for the ALJ to believe that we should have a hearing to flesh all this stuff out. And they've basically said no. And to go back to the question that Judge Deal was asking me about harmful error, I agree. They didn't say specifically, we accept that he was going to be temporarily and totally disabled, but there was a proffer that he was going to be temporarily and totally disabled. And looking at the evidence in the light most favorable to him, and assessing whether or not that gives rise to a reason to believe that there may be a change of condition, I think not addressing that proffer either by the ALJ, which is really not what's before you, or the CRB's kind of conclusory statement that there's a proffer about a change in condition, but not considering that change, that proffer is harmless error. It's circular logic. Right? Why?
Can I ask you about your proffer? You keep saying some things about the proffer, and I'm having trouble fitting what you're saying your claim is now with what I remember from how it was presented at the time of the I don't know, Snipes sort of status hearing rather than evidentiary hearing, because the way you're describing it now, your claim was not really, here's Mr. Quaranta's current condition, it's disabling, and he wants benefits, not just medical benefits, but wage loss benefits. Rather, you're saying your claim was, and your proffer was, he's got to have the surgery for medical reasons. And once he has the surgery, he will be disabled. And that's my claim. And my proffer is, that's the nature of the proffer. And when I'm looking at the proffer, first of all, the claim seems to be, the administrative law judge is talking to you and saying, so the TPD would be from June 19, and then you say 6/19 to present and continuing, and you say correct. And then you make some statements about the worsening of his condition, not the consequences of his medical treatment. Now, there is a part later, a little bit later, where you say he's going to require active care, and we don't know how the surgery is going to go. So there's a little bit that's forward-looking, but I hadn't really understood that your claim was contingent and future in this way, and I'm not sure that the ALJ or the CRB did either. And we'll find out, I guess, whether your opponent did. But am I missing a part of filing or something that would make clearer than the proffer does the nature of the claim as you're currently describing it?
Well, I think that was a colloquy between the court, and they were asking about partial disability, which I think that's a harder row for Mr. Quaranta to hoe, right? Because the disability changed from permanent to temporary, but the wage loss is still partial. And I think that the voluntary limitation of income finding is a problem for him on the partial disability. Clearly in the briefs at the CRB, and maybe imprecise language by his counsel at the hearing, that issue of the temporary total during the recuperative period was really kind of the gravamen of the change of condition, and certainly was at the CRB. And again,
can I ask you? So again, is your change of condition claim also future, contingent in that way? Because, and what I mean by that is, obviously, if he has the surgery, immediately after the surgery, his condition will be worse. Will be different and changed. He'll have, had a surgical operation, and he'll have to recuperate, and he'll have, an open or, a closed surgigical incision, and his condition will be different post medical procedure if he's allowed to have it, at employer expense. But is it your view that for him to have a temporary total disability claim arising from that procedure, he has to show first that his condition got worse, triggering the need for the procedure? Because if I recall correctly, although the 2014 report by Dr. Crutchfield, I don't see it as in our current record, it recommended this procedure surgically, and he did not take it. And so if all that happens is, at a time, if the time of the original litigation, he needed the procedure according to the doctor, he didn't take it. And then nothing really changes except that he decides ultimately he is going to have the procedure, but his condition doesn't worsen. Do you think he would be entitled to a period of temporary total disability to recuperate from that procedure? Or do you think he kind of lost that shot by not taking the procedure earlier?
I don't think he lost that shot, but those aren't the facts of this case. He did get worse. He did go back for care. He got to the point where he couldn't deal with it anymore. So it did deteriorate. But I think if all he did was cure his poor decision by not getting the treatment, then he could. I thought you were going to ask me a different question, which is, does this allow him to somehow get back to where he was on partial disability. And I don't know the answer to that question, but that's not really what's before the court today. What's before the court is this period of temporary disability associated with the medical care, and whether or not that allegation and claim by Mr. Quaranta gives rise to a reason to believe that there's been a change in condition. It's a very soft standard. And again, he could lose this on the record. All the questions you're asking, the ALJ could say, I don't find his complaint that he got worse credible. I don't find that the surgery is going to render him temporarily and totally disabled. But that's not the issue here. The question is really whether or not there should have been a hearing on a change of condition. And I don't.
Mr. Brascola, can I just ask? I just want to make sure I understand what your argument is as to why your client's current claim is not barred as a matter of law by this court's decision in 2018 that the causal link was severed permanently by his voluntary retirement.
The causal link for the claim for permanent and partial wage loss. You can't, it did not say that all wage loss forever. What it said is his wage loss, the difference between what he was earning as a soccer player and what he was earning running the pipeline league. He made that decision voluntarily. That certainly does not suggest that if he got worse and now he's got a period of total disability, that some unforeseen worsening is barred by his, because the law of the case is clearly his inability to play soccer and the wage loss caused by soccer. I understand the question, was found barred by his decision to retire, right? Because he's got a partial wage loss. You have to put that court's finding in the context of the claim that was disposed of, which was a permanent partial disability wage loss claim under a different section of the statute.
So is there anything in any of the decisions of this court that supports this kind of more nuanced approach?
Yes, Cherrydale, it's an old case. It's really, and I didn't cite it in the brief because I didn't know we were going to go here. But there's a case called Smith, which stands for the proposition that once an injured worker receives permanent and partial disability benefits for a scheduled injury, they are no longer entitled to to temporary and total disability benefits. The Cherrydale case, which is a case of this court, says unless there's some unexpected and unforeseen worsening of the condition, and then Smith no longer governs, and you can get another period of temporary and total disability after the permanent and partial disability benefits for a scheduled member were paid, even on the assumption, the reason that we get paid permanent and partial disability benefits on a scheduled member in DC is there's a presumption there's going to be future wage loss because of that injury. If the future wage loss is not exactly what was anticipated, and I think in Cherrydale might have been a knee replacement case where someone had a scope and nobody thought there was ever going to be a total knee replacement, and years later there was a total knee and a period of temporary total and some additional permanent partial that the claimant actually got in that case. Worked for Cherrydale Electric. So yeah, there are very nuanced decisions throughout the history of the act based on the nature of the disability benefit being claimed. You can't pay, the temporary and total is different than permanent and total, is different than permanent and partial, is different than temporary and partial. This is a completely different benefit claim than that which was before the court in 2017.
Can I just ask?
Direct answer to the question, Judge Kravitz.
And this might not be, I'd be happy to have this question on rebuttal. In fact, I think you might want to reserve it for rebuttal. It's not clear to me that the ALJ or the CRB understood that you were making the argument for them that you're making to us now, that your claim was for a recuperation period of total disability. It wasn't clear to me from the briefs that was your argument. So on rebuttal, if you can do your best, give it your best shot to show me where you articulated this argument to the ALJ and the CRB, I would appreciate that, because I'm looking through what I've seen so far, and I'm not sure I see it.
Okay.
But I'd like to hear that on rebuttal.
I will reserve whatever time I have left. Thank you, Your Honor.
Yes, counsel, we'll give you your 3 minutes to rebuttal. So we'll hear now from Ms. Terroch.
Thank you. Good morning, Your Honors. May it please the court. Cheryl Tarachi on behalf of Major League Soccer and DC United. A lot of things to cover, but I want to start out by saying that, Mr. Quaranta argues that he has established a change or a worsening of condition. And we can talk about Dr. Crutchfield's report, we can talk about the proffer, we can even talk about the difference in the benefits being sought, because I also have been somewhat confused as this case has gone on. But I will submit to Your Honors that it doesn't matter. None of that matters. We don't need to get there because this court has already decided the issue, the entitlement to future wage loss benefits. This court has already ruled that Mr. Quaranta is not entitled to additional compensation or wage loss benefits. So regardless of how creative the argument is or the new benefits being sought or the theories that are raised, it doesn't change the fact that this court has already denied that future claim for compensation.
Can I ask you, first of all, a question about what's in dispute? Does the employer slash intervener contest Mr. Quaranta's entitlement to medical benefits for that surgery if it is medically, deemed medically appropriate?
So to answer your question, Mr. Quaranta's medical benefits remain open. So they are not impacted by this particular claim for compensation or benefits that we are discussing. To my knowledge, Mr. Quaranta has not requested my client authorize or pay for the surgery. So
if it were determined to be medically necessary and to be causally related to the elbowing incident, would your client have any other ground for opposing the payment of those medical benefits?
To the extent, as Rodder indicated, that the procedure is determined to be reasonable, necessary, and causally related to the work-related concussion, I do not believe my client would be raising a defense, especially not with regard to the issue that we're discussing today.
But you do contest, even if those two things are true, even if that procedure is medically necessary and appropriate, and even if the reason Mr. Quaranta has to have it is because he was elbowed in the head while working for your client, you do contest his ability to get any temporary wage loss benefits during a period, assuming it were proven that after that procedure, nobody'd be able to work for several weeks, or months because they would have to recuperate. You do contest that.
I do, Your Honor.
And why does that make sense? I mean, why does that make sense? Why is that reasonable or fair under a humanitarian statute? If you agree you have to pay, notwithstanding that you're retired, you have to pay his medical benefits thereafter, but you're saying you don't have to pay, even if it could be shown that the only reason he has to have this procedure, he's gonna be laid up, he can't work for X period of time, is because of the work he did for your client. Why? I mean, leave aside for a minute what we already held in this case or others, but just could you explain why you think that makes sense under the statute?
Because that's what the law is. That's what the court has previously determined. This exact claim was raised in the Burge case. And I know you said put aside the voluntary limitation of income finding.
Well, no, I understand I asked you to put aside something which you haven't put aside, which is fine. But could you explain why you think that is a fair and just way for a system to operate as an original matter?
And part of that is the nature of you talked about this earlier about the kind of anticipatory and prospective benefits, and the nature of this modification provision in the statute. And I want to touch on the Terrydale case that all goes together. So when a claim for permanent partial disability, either under the schedule or wage loss benefits is made, the ALJ or the CLB considers what is anticipated. So at the time Mr. Quaranta made his claim for permanency benefits, the surgery was already discussed. It was already recommended. It was anticipated. So if he had gotten an award for benefits, we would be in the same position where he would be requesting a modification for a worsening of condition, seeking additional wage loss benefits. It's a very narrow kind of carve out once you've gotten an award to be requesting benefits. And as Mr. Buscola pointed out, there's a line of cases And this is what we would have gotten to if this case had proceeded to an evidentiary hearing. And the Cherrydale case does talk about what is determined to be a worsening or an unexpected occurrence. And essentially what the court has said is it really must be something that is unexpected. And I believe the wording used is something to the nature of an amputation. So we're not talking about just a worsening or a deterioration or, a surgery that he maybe didn't want to get back then, but now wants to get now because it hurts a little bit more. The courts have said it is something of a significant nature that could not have been anticipated at the time of that permanency award, much like something like an amputation.
But this point doesn't matter to your legal analysis because you would have said back in, in the initial claim, doesn't matter if he needs a surgery, the causal nexus has been severed under 32-1508 V3. And so again, I'm going to piggyback on Judge Baptiste's question. Why do you think V3 says that? I mean, I appreciate that you won that prior claim. I just read the language of V3 and I tend to think, if it's a late arriving disability, if somebody voluntarily diminishes their salary and then involuntarily it gets diminished further, why we would take that initial voluntary diminution of salary as precluding a later claim for the involuntary diminution later. Does that make sense? I don't see V3 as really speaking to that situation, even though I tend to agree with you that we might have said that it does.
I think there's a couple of different ways to look at it. One is it's a bit of a punishment mechanism as it goes to the wage law statute, that it is the claimant's voluntary choice to have removed himself and not taken, a well-earning position, and he's now put himself in.
Why do you want to? It seems odd that you want to punish people simply for retiring. I guess maybe as I'm getting older, that seems more poignant. But let me give you a simpler hypothetical. So let's say I have a relatively high-paying job, and I get injured on it. And it doesn't really interfere with my continuing to work on that high-paying job. And I work on that high-paying job for a couple of years. And then I retire because, I want to go spend more time with my family and, garden and do the things that people want to do. But I don't completely retire. I retire my high-paying job. I decide I'm going to work, at a different job that is less demanding and I can work part-time. And so then I have a new job and I'm working, and I'm making, X $1,000, way less than what I used to earn. And then, and I know this is going to be a latent injury or a latent disability feel to it that may or may not be, I know you don't think it's raised, and I'm not sure it's trying to be raised, it's more an analogy, but then imagine that it's undisputed that as a result of that original workplace injury, the person in this hypothetical who is retired but still has a job, a less high paying job, ends up getting condition worsened so much that the person cannot work at all, cannot work no job, it's just completely disabled. Do you say zero workers' compensation for such a person because you want to punish the person for retiring? I don't see why you would want to punish such a person or why you would want to foreclose a workers' comp claim. I get the idea that the person who raises such a claim shouldn't be able to try to get the wage loss measured against the pre-retirement high-paying job. I get that 100%. And that's, sort of what I thought we were saying in our earlier decision in this case. I get that, but I don't get yet why the statute does or should foreclose a claim in the example I gave. But do you think it does foreclose that hypothetical example, zero recovery, because you want to punish retirement?
I do agree with the result. I disagree with my own words. And my words are more reflective of my morning with two toddlers, and I'm lucky to have gotten in front of this computer. So I will take that back on behalf of the defense bar and injured workers. Because that was a personally bad choice of words. But it goes back to the severance of the causal link. So in your hypothetical, the choice to retire from that higher paying job now has more to do with your personal choices or the hypothetical person's choices in life, and not as a result of the workplace injury. So at
No,
what
and I
point
get that it severs the causal link relative to the wage amount for the earlier job. That makes perfect sense and should be the law, and I think is the law in light of our case. Is quite clearly the law. What I don't get though is why you want to carry. I don't mean it's not criticism of you. I mean why it would make sense to carry that idea all the way to say it severs not only the causal link between the loss of job one, high-paying job, but it also severs the causal link to the loss of lower-paying job two. Why does it logically sever that link, or why in law should it be viewed as somehow as a legal fiction severing that link?
And I think that is where, Mr. Quaranta is trying to differentiate the difference between a partial disability claim and this total disability claim, that is kind of a closed period in time related to the surgery. And the best that I can submit to you is that the court has said it has, and that the nature of these awards in DC are that they are prospective.
When you say the court has said it has, are you referring to the 2018 MOJ in this case? Are you referring to Franklin? Are you referring to Powers? What's your strongest authority for us having said that?
I'm referring, so Powers and Belials have the same principle that discussed the severance of the causal link, but Burge, I believe, is on point. In that it dealt with a professional athlete who, similarly to Mr. Quaranta, chose to voluntarily retire from professional sports when Burge had other offers to return and to play. And what's important is the claim for compensation benefits in Burge was temporary total disability. Those were the benefits being sought. And the court held that because of the voluntary...
Wasn't the reference point in Burge, just remind me of Miss Burge didn't take a subsequent job, right? So that she had gone from WNBA salary to nothing. And so it makes some sense to say, look, you voluntarily diminished your salary to nothing. It makes less sense to say when you voluntarily diminish your salary to a fraction of your prior salary, even that fraction is non-recoverable because you voluntarily diminished to that fraction when that fraction goes away because of a temporary total disability. I mean, that was a lot of words. Hopefully you can follow that. Why isn't that a distinction of Burge?
It's a distinction in Burge that I don't think makes a difference based on the precedents in the case law, because the court has held on more than one occasion that the severance of the causal connection link applies to compensation to wage loss benefits.
Have we ever applied it in a context where a person left a high-paying job voluntarily, so there was some diminution, some voluntary the diminution in salary, took a lower-paying job, and then as a result of disability, assuming that, and change of condition and disability, assuming those things could be proven, I know some of them are disputed, ended up being unable to perform that lower-paying job or any job if it were going to be, let's say, a total, it could be a permanent total disability claim ultimately. Have we ever done it? Have we ever applied that in a setting like ours where there is a second job and then a claim that due to worsening, even the second job, less high paying job can't be performed, at least temporarily?
I cannot recall a factual scenario exactly on point to all of those facts.
That sounds like Franklin to me. Why isn't that Franklin? That was the one where she went to take a higher paying job, in fact. And then within a week, she had to quit because of her carpal tunnel. And we said the causal link from the prior job has been severed by virtue of her taking a new job. I mean, maybe that's a question for Mr. Bosco. I mean, it's a friendly question to you, so I suppose I'd like to hear his answer to that.
That case wasn't coming to mind, all the intricate details of the case. I do recall it being on point.
It was a temporary total disability claim. So anyway, I'll direct it at him.
I have one question. What are you all fighting over here? How much does he earn now, and how long is he going to be recuperating, and what's at stake here?
We don't know. So compensation benefits are governed by his pre-injury average weekly wage. So it would be based on his wages at the time that he was playing for Major League Soccer and DC United. But this goes to kind of the second part of the question is,
well, can I interrupt you there? Because I think it's pretty, can I interrupt you there? I think it's pretty clear that although there's some things that are unclear about Mr. Quaranta's claim, I thought one thing that was clear is that he's not claiming that he should be compensated for wage loss measured against his MLS salary. I thought, and we can ask, I guess we can clarify that with Mr. Boscolo on rebuttal also, but I thought he was claiming that if he was going to get benefits for wage loss, that they would be measured against his new salary, his lower salary. But you disagree. You think he is, you understood him to be claiming that if there is temporary wage loss, it will be measured as against Mr. Quaranta's MLS salary.
I will allow Mr. Boscolo to clarify what he is seeking, but that is my understanding of the compensation rate to which temporary total disability benefits would be paid. But I want to answer Judge Kravitz's question just briefly, if I may, because I believe it goes to the second part of the issues in this case, which is, was there sufficient evidence to meet that threshold burden? And if you look at Dr. Crutchfield's report and the evidence that's been discussed, the time period of recovery or that he will be temporary totally disabled is not discussed in that report. We don't know. So this isn't something like a back surgery where we know he's going to be laid up for a number of weeks. This is an occipital nerve release procedure that's been discussed. I'm sure we can all speculate as to how that may or may not affect Mr. Quaranta's ability to do his current job. But Dr. Crutchfield doesn't provide that opinion. He doesn't provide any evidence to support this deterioration or discussion of the complaints and the disability that is being sought.
I know your time is up. I did want to get your position on one thing, which you've touched on a little bit, but I want to see if I can get it quite clear. Mr. Boscolo has described his claim in part today as a claim that is related to the recuperation from the surgery and limited to a period, kind of a predictive future period of inability to work during that recuperation period. You said something a minute ago suggesting that, or arguing that Dr. Crutchfield's 2019 report doesn't address doesn't provide factual support for that claim. So understood. There have been some questions today of Mr. Boscolo about whether that claim presented that way was preserved in front of the agency, whether it was presented to the ALJ, whether it was presented to the CRB. Do you have a position on that? Is it your view that if that's his claim, he's raising it for the first time today and we shouldn't consider it, we should treat it as not preserved? Or do you think he did present that claim in the administrative proceedings?
It was my understanding going into the hearing before the ALJ that the claim was for temporary partial disability wage loss benefits. At some point between that argument going forward, that claim was amended.
There was a different issue. I think his original written application was for permanent partial disability, and then he withdrew that orally and changed it to temporary. But I thought that was a little bit different. I thought that was on the theory that he's got problems now. He can't work now. He's going to have the surgery. We don't know how the surgery is going to work out. He's not at maximum medical improvement, so we can't have a permanent claim. It has to be temporary now, and then we'll see what happens after the surgery. But my question is about, I think his claim, I was asking about a slightly different claim, which is the idea that he's fine right now. He's able to work at his current job. He has no wage loss. He's got no issues other than he needs a medical procedure. But once he has the medical procedure, he is going to have an issue, and we're trying to establish his right to temporary total disability during that period of recuperation. My question about that claim is that exact claim. Do you think that issue was presented to the ALJ and to the CRB, or do you think it was not?
I don't think it was presented clearly. I don't think it was my understanding that that is the limited issue that we were talking about. I will submit that the claim for temporary disability benefits was raised to the extent that that may encompass temporary total, I will defer to your honors. I think that's a legal determination. So that was not my understanding, but I will submit that the claim for temporary disability benefits was raised, whether that is a difference between partial versus total, or whether that was simply not clarified appropriately for the ALJ to have addressed it. I will leave that to your honors.
Thank you. Unless my colleagues have other questions, we'll hear from Mr. Bosco in rebuttal, and we'll give him his 3 minutes in rebuttal.
Thank you, honors.
Mr. Bosco, you're muted.
Judge Deal, I'm going to try to do the best I can in 3 minutes to answer some pretty complicated questions. Page 3 of my brief, I specifically laid out, and I stand corrected, Judge McLeese, Mr. Quaranta did miss some limited period of time right after the injection. And he said he was there to testify about that. And in page 3 and 4 of my brief before the CRB, I specifically raised the issue of temporary disability, both after the injection, and I said in my brief these specific words to the CRB. I had it and then I moved. He is now not able to perform all of the duties of his current employment as a result of the work-related injury. Of all the unclear things I said in this case, I think nothing could be clearer than he's now saying that this injury prevents him from doing the duties of his current job, not his own thing. And yes, I think that I have a problem on total disability because of the prior findings of this court, which is why it was partial disability, right? I claimed temporary partial. I raised it both during that short period of time after the injection and during the recuperative period. The footnote in my brief says, Mr. Quaranta was sitting there at counsel table with me, ready to answer any questions of the court if the ALJ was not clear on what specifically Mr. Quaranta could not do now because of his work-related injury. So I specifically raised that both after the injection and after the surgery in my pleadings to the CRB. If it wasn't clear in the proffer, you know, sometimes when we're together and we're watching body language and it's clear to everybody that we're all talking about the same thing, our words don't necessarily make the greatest record, which they have not done here, number one. Franklin, I want to talk about Franklin for just 1 second. The problem with Franklin is when she left her employment, she deprived the employer of the opportunity to give her light duty while she was recuperating from carpal tunnel, right? And so that employer could have eliminated her wage loss in another way besides paying workers' compensation benefits. Unfortunately, I know Franklin and Burge very well because they were both handled by my firm. I handled Burge myself. Miss Burge left professional basketball because of a skill set that the only one on this video conference has is Miss Tarachi. She decided she wanted to be a mom, and that's why she stopped playing. And then when her back flared up, she did seek temporary and total disability benefits, but she had already left the employment to become a mom, and the court found when you decide to hang them up, they're no longer responsible for wage loss that happens after you have a baby. And so I don't think either Franklin or Burge are anywhere close to Mr. Quaranta's case. And temporary partial is different than permanent partial, and temporary disability.
I'm sorry, could you just, I just missed the distinction of Franklin. What is it?
So So Franklin leaves job 1.
Right. Goes to take a higher
job
paying
2,
job, which she has to leave within a week.
Needs a surgery for carpal tunnel. So when a person can't do their full duties, the first way an employer can take care of that is they can let them work light duty, answer the phone, they can pay them full salary while they're recuperating. There are lots of ways there can be no wage loss.
But by leaving DC United, why didn't Mr. Quaranta deprive DC United of an opportunity to, put him in a administrative position that would have paid him every bit that he's making now?
Well, A, that argument wasn't made, but B, there are no light duty soccer jobs. I mean, he can't go back to play soccer at all. And I don't think his retirement deprives them of that. So I think when you look at Franklin, it is not the same as the situation here at all. And certainly Burge is not the same as the situation here. And, I am out of time. There are lots of other things I would like to say, but I don't think the court should decide this case based on how much money Mr. Quaranta will or won't get and how much he has or hasn't made, because this case has wide applicability to working men across the District of Columbia.
All right, thank you. Thank you, counsel. The case is now submitted and you may leave the virtual courtroom.
Bye, Chair.
All right, we're ready to call the second case, which is U.S. Bank Trust versus Omid Land Group. Ms. Martinez, you may proceed.
Good morning, and may it please the court. I'm Melissa Martinez, representing the appellant, U.S. Bank Trust, as trustee for LSF 9 Master Participation Trusts. Good morning, Your Honors, and I'd like to reserve about 3 minutes for my rebuttal. Had we convened this argument, Your Honors, at the beginning of last week, my argument would have been different than what it is now. On Thursday, a different panel of this court issued a decision in the RFB versus Deutsche Bank case, which articulated new law on how courts should view the conscionability of a sale price at a condominium foreclosure sale. Now, Your Honors, I'd like to tackle that issue because neither party briefed it, and it's germane to these issues. The other issues that I'd like to address, the erroneous advertisement, the propriety of the court's issuance of judgment as a matter of law, and the denial of the motion to amend, have all been briefed, and I'm prepared to argue those as well.
Ms. Martinez, can I, before you get to the RFB properties, can I just ask you a question about the record having to do with the sales price?
Yes, Your Honor.
And I don't know if you have your appendix readily accessible to you.
I do.
But starting at page 14 of your appendix is the trustee's deed of foreclosure for unpaid condominium assessments. And that goes on for, and everyone's talked about that in the briefs because that has the language about the sale being subject to prior liens and mortgages and all that. But I want to ask you about pages 17 and 18. Because there's also been discussion about the absence of any evidence in the record as to what the fair market value was at the time of the property at the time of the sale. So on page 17, there's this stuff about recordation tax fees and transfer tax fees. Do those figures tell us anything about the fair market value of the property?
Yes, Your Honor. I believe that there is a formula that determines what the recordation fee is. It's not in the record. However, and off the top of my head, I don't know what that formula actually is. But what we do know was that the sale price here was $63,000, and that the condominium foreclosed the lien, the notice of lien, was about $13,000. We don't know, though, what happened with the rest of the proceeds and whether or not that difference between $63,000 and the $13,000, whatever recordation fees there were, ever made its way to the first lien holder. And that's one of the reasons why, we've got to remand this case back to the trial court so we can figure out where did that money go and what happened to the proceeds.
Can I ask you about that argument? That argument sounds new to me. Is that a point that you made in your brief that, leaving aside everything else, even if the sale was valid, there's a question of some missing money that should have flowed through to your client? I just don't remember that in the briefs.
Well, Your Honor, it was part of the discussion on the motion to amend, because the amendment would have brought in the condominium association, which is the party that conducted the foreclosure sale. And so there are claims relating to either unjust enrichment, declaratory judgment against the condo association that the trial court did not allow U.S. Bank to proceed with. And so one of the issues.
I interrupted Judge Kravitz's question. I know he had a second part about another part of the record, so I want to get you back on the rails of his question.
Yeah, there was a claim in the proposed amended complaint that alleged that the condo association kept more than 6 months worth of assessments for itself. But I guess my question, Ms. Martinez, is does the $13,700 some odd dollars in recordation and transfer tax fees, does that line up with a sales price of $63,000, or this seems like a lot for a sales price of $63,000? I guess I'm trying to figure out, does it indicate to us what the fair market, something other than $63,000 as the fair market value at the time of the sale?
You're right, Your Honor. It is a large amount if we're only considering $63,000. If you look on page 18, there's a consideration amount listed of $474,310. I'm not entirely sure what that is, but that seems to be more in line with the amount of the recordation fee in this particular case.
Okay,
So
so
are you
that actually was
suggesting-
I'm sorry, that was my next question. What, you don't know what that means?
I don't know, Your Honor. It looks like a printout from the land records itself.
And if you don't know what it means, and we don't know where it came from, well, let me ask you a related question. Did you bring it to the attention of the trial court as part of the factual basis upon which the trial court should deny summary judgment?
So, Your Honor, the opposition to the motion, to Omid's motion for summary judgment discussed the invalidity of the sale price. I don't believe that it went into detail with respect to the different amounts.
And
Omid
so
did request-
is it your view, though, that we should rely on this figure in this document that we don't know where it came from, we don't know what it means, and it wasn't brought to the attention of the trial court as a reason not to grant summary judgment, but that we should consider it as supporting a reversal of the trial court's grant of summary judgment?
No, Your Honor, what I am advocating is that the court follow what happened in 4700 Con, which is not to deal with these issues on a de novo review, but send it back to the trial court so it can figure out all of these issues. What we've got here are a number of issues that need to be ironed out, namely, we've got an opinion that issued on Thursday that has bearing on whether or not a sale price is unconscionable or not. We've got an affidavit that.
Let me just take a pause, because what the trial court said is what you guys said about unconscionability was too conclusory to allow any meaningful review. And when I look at the complaint, when I look at the opposition to summary judgment, what I see is sort of bare assertions of this being an unconscionable sales price. I don't see any evidence of what the fair market value is. I do see that in the complaint, and that there's evidence of what the remaining principal balance on the loan is. That's something. But none of that's being teed up for the trial court. So I'm somewhat sympathetic to the trial court's view that you guys did a very conclusory job of making out an unconscionability argument, and that it's not for the trial court to do all that work for you. So do you want to point me to where you think you've substantiated an unconscionability argument in the pleadings below?
Well, Your Honor, if I can take a step back here, because I think there is a fundamental issue with respect to what was pled in the counterclaim and what was actually requested on summary judgment. The counterclaim itself dealt specifically with Omid's assertion that there was a gap in the chain of title that eventually led to U.S. Bank. And that gap in the chain of title meant that when they purchased the property during the condominium foreclosure sale, that they became the first deed of trust. There was no mortgage that they had to assume. That was the declaration that they wanted in their counterclaim. That is a very different issue than what they moved on summary judgment. On summary judgment, the issue that they put forth in front of the judge was to seek a declaration that the first deed of trust was void under the DC law and the Chase Plaza, Liu, and 4700 Con case law. So
right, and once they raise that in their motion for summary judgment, you have a chance to respond. And you can respond by saying, here, I'm going to marshal such factual support as is necessary to show that's not a good argument. And the way I'm going to show it is that that would really be unconscionable. And here's what if it's not already in the record, you could say, Judge, we need more discovery because we didn't see this coming. So there are ways to flesh that out, even if it sort of cropped up in your mind. I don't mean you personally, but even it kind of cropped up later in the litigation than it might otherwise have. So are you saying your client didn't get a fair opportunity to explain in writing and create a factual record to support its view that any transfer here was invalid because of the nature of the notice and the, in your view, unconscionable sales price?
That's right, Your Honor, and that's not the way that in which discovery had proceeded. And so what we tried to do was amend the complaint, add a party, the condominium association, to really figure out what happened at that sale. Because what we see even now with the RFB case is there is an open question as to whether or not the condominium association, which is the party that conducted the foreclosure sale itself, is a necessary party. That's still an open question. By the time that we filed the complaint in this case, 4700 Con had not yet issued. The law has been in flux. And so the way that discovery was conducted in this case, Your Honor, was tailored to what was in the counterclaim as well. And so when we get to the summary judgment stage where we had to put forth all of this evidence relating to the sales price and all that stuff, we tried to amend the complaint so that we could get a fulsome discovery on that discovery on those issues. Now,
but of course, with your motion for leave to file an amended complaint, as with your opposition to the motion for summary judgment, all you gave the trial judge was some boilerplate, non-factually focused pleading. You didn't even explain until your motion for reconsideration, you didn't even explain to the judge that you'd just gotten discovery responses and that for the first time they were arguing Chase Plaza. So you just put this boilerplate stuff in front of the judge and didn't explain anything.
That's right, Your Honor. And, I was not counsel below, so I can't tell you what was going on in their minds when they were presenting that information. But our client should not be penalized for losing its security interest in about $500,000 of worth of property because it was not briefed properly, but the issue was preserved. And so what we see now is a $63,000 sale price in Omid's own words in its counterclaim, them believing that notwithstanding the language in the deed of trust, that the sale was premised on the assumption of the mortgage, they specifically state that Omid, through its managing member, verifies that it was Omid's understanding that fee simple title acquired by Omid pursuant to the trustee's deed vested ownership of the property in Omid free and clear of the purchase money encumbrance or lien created by co-defendant Snowden based on the gap in the chain of title. The trial court never dealt with that particular issue, and it's particularly relevant here in light of the RFB decision, which essentially states that if you assume the mortgage, the first deed of trust, then you can basically add on that amount to your foreclosure sale price to come up with a price and determine whether or not that's unconscionable. But Omid, in his own words, was telling us it knew it was not assuming any liens or mortgages on the property when it was purchasing it.
Well, can I quibble with the use of the word no? Yeah, I mean, in philosophy, knowledge is sometimes referred to as justified true belief, and the reason that they gave was not a good reason, right? So they thought they knew, they believed for a different reason, right?
They believed it for a different reason, Your Honor, but based on the RFB opinion, which specifically states that we've got to look at the circumstances surrounding the sale with a, quote, proper temporal lens. That's all we have on the record, and that's in their own counterclaim, and that is germane to the issues here. So rather than this court hashing all of these issues out on a de novo review, you can send it back so that we can get the record that you need in order to make the proper legal determinations.
Can I get your,
you know,
can I ask you about, you relied on 4700 Connecticut Avenue and said, this is really like that. We should do what we did there, which was, there was an unconscionability issue. And we said, oh, the trial court needs to figure that out. It seems to me there's at least a potential difference that I'd be interested in your addressing. In 4700 Connecticut Avenue, we said, really, the trial court hasn't addressed the unconscionability claim. And we're not going to sort that out in the first instance. We're going to send it back for the trial court to do that. Whereas, so we weren't really saying that survived summary judgment or anything else. We were just saying we need a ruling from the trial court on that issue. We had a ruling from the trial court in this case. And the issue is an issue, maybe not the only issue, but an issue different from the one in 4700 Connecticut Avenue is, you know, did your client put on enough to survive summary judgment on an unconscionability type claim, or didn't it? And I'm not quite sure why. So that we remanded in 4700 Connecticut Avenue doesn't seem to tell us much about the answer to what seems like a different question, which is, was a trial court summary judgment ruling correct or not?
Your Honor, my time is running out, but I'd like to answer that question if I may. And my response to that is because the condominium association was not a party as of that time, because we didn't know that this was what Omid was seeking summary judgment on, because it was a different issue than what was in their counterclaim, that we should at least be given the opportunity to create a record on that particular point.
Thank you, Counselor. Your time is up, but we'll
Thank
give
you.
you your 3 minutes in rebuttal. We'll hear now from Ms. Buck.
Morning, Your Honors, and may it please the court. My name is Tracy Buck, and I, along with my colleagues Stephen Hessler and Ian Thomas, represent the appellee Omid Land Group. We ask the court to affirm the lower court's 2 decisions, holding that Omid is entitled to summary judgment and denying U.S. Bank leave to amend their complaint. We ask the court to affirm these rulings for 3 reasons. First, U.S. Bank failed to protect its lien. Second, the record is devoid of any evidence to warrant invalidating the condo sale. And third, it would be extremely prejudicial to allow U.S. Bank to amend its pleading to add new claims against Omid based on the same set of facts and law that was available to it when initiated this case. Your Honors, this appeal is nothing more than an attempt by U.S. Bank to try and correct almost a decade of its own failures to protect its lien. Now, the super priority statute is designed.
Why should it have known that it needed to protect its lien, given the advertisement saying that this foreclosure sale would be subject to its lien? And the fact that there was no law at that time that would have proven otherwise.
Your Honor, the law that did exist at the time of the foreclosure sale was the Chase Plaza case. And that's the seminal case where this court advised, if not warned, mortgage lenders that they need to take proactive steps to protect their lien. And this court gave examples of how
at that point, including that it's subject to a lien in the advertisement might have been enough, right? I mean, we hadn't said otherwise until 2018.
Well, as this court noted in RFB, the law was uncertain at the time of the foreclosure sale. So super priority sales that were conducted after Chase Plaza, but before Liu and 4700 Con, the law was uncertain whether a first deed of trust encumbered a property as a result of a super priority lien sale. And this court stated that that needed to be considered in the context of the price, and that it's almost baked in the price. And this court found that there was no finding of unconscionability based on that temporal lens of when the sale took place alone. Now,
no, I agree with you that that's baked into the price. I mean, that's what we said just a few days ago in RFB. But what we don't have is any kind of finding from the trial court saying, well, when I consider that it's baked into the price, this $63,000, that's, as a matter of law, not unconscionable. Instead, what we have is it's a conclusory allegation of unconscionability, despite there being pretty clear evidence that $63,000 is something less than 20% of the principal balance remaining on the mortgage, something that you might use as a metric for gauging the rough market value of the home.
Your Honor, as this court, I think, noted, one of the issues is that the record at the trial court level is bare. and US Bank did not cite to any probative evidence to dispute any of the material facts asserted by Omid within their summary judgment motion. Moreover, in the RFB case, this court noted that a $53,000 purchase price based on a tax-assessed value of $500,000 was not unconscionable. And here we have a $63,000
I'm sorry, we said it was not unconscionable, or we said it might not be?
I believe we said it was not unconscionable, Your Honor. And so in the facts here are substantially similar to the facts in the RFB case.
Yeah, but our RFB was a finding that the finding was at the trial court below that we ended up reversing was that, this is unconscionable. This is so low. And then we reversed by saying, actually a lot of this risk is baked into the price. So go ahead and reconsider it. I don't think we said, correct me if I'm wrong.
No, you're not wrong.
Okay. I don't think we said, that is necessarily not unconscionable. You have to reconsider it in light of baking in the risk factors. And the trial court really didn't do that work here. Now I take your point that the record's quite bare, and so maybe that's enough of an answer. But I don't think we said as a matter of law that it's unconscionable, that it's not unconscionable at that price.
Your Honors, again, one of the issues with the lower court is that there is no evidence they cite to even note that there's unconscionably low sales price. And so the court found their argument wanting, and the issue of unconscionability is on appeal today. And so while US Bank requests a remand and that we blindly follow 4700 Con, I think that the procedural posture of this case is manifestly different. For example, in the Liu case, there was a robust record of the fair market value. There's no evidence that there was depositions taken by the condo purchaser as to what they believed the fair market value of the property was. There was testimony by the condominium association as to what their intentions were with the misstatement in the ad. But here we have none of that. And that's one of the issues.
I'm sorry to interrupt, but do you know what these numbers mean on pages 17 and 18 of the appendix? Because these were in the record. In fact, this trustee's deed was an exhibit to your motion for summary judgment. So this was absolutely before the trial judge at the time of the summary judgment ruling. And I guess I'm just wondering, I mean, I know there was no affidavit or anything saying, well, this is what these numbers mean. But I mean, someone looking at this at a document that says consideration amount $474,310 might think, well, at a minimum, there's a dispute here as to whether the 63,000 sales price is unconscionably low, given that this document that's in the record suggests that the real understood price here was $474,000. Or is that just too speculative?
I think that the 63,000, I think that it is too speculative to answer your question. And that was not even cited by US Bank to claim that there was a dispute of fact. The 63,000, again, I would argue that it is, in considering the context and the commercial setting and the factors surrounding the foreclosure sale at the time after Chase Plaza and before Liu and 4700 Con, the $63,000 purchase price reflects the uncertainty at the law, and we cannot find that it would be unconscionable. And I ask that this court find that it is not unconscionable here. Moreover, as this court and
I'm sorry, did you just ask us to find that it is not unconscionable?
No, sorry, I asked that this court affirm the finding of summary judgment. But I would also argue that there is no unconscionability here. Moreover, as this court noted in Liu, these super priority lien foreclosures generally produce a low sales price due to the inherent nature of the super priority lien, and that they encompass only generally a couple $1,000s worth of a lien and 6 months worth of dues. And so US Bank is essentially requesting a do-over here. And as this court noted, their frustrations are to be, the solution to their frustrations is with the legislative process and not with the judiciary. And so I think that it's important to note that one of the hallmarks of unconscionability is that US Bank has to assert that it lacked a meaningful choice. And here it failed to take action to protect its lien in the wake of the Chase Plaza decision by paying off the condo dues, escrowing the funds, or even participating in the sale. I think that as a result of the Chase Plaza case, we have sophisticated institutional lenders that were put on notice that they needed to take proactive steps. And one could argue a nominal step of just submitting a couple $1,000s to the association to pay off these dues. The statute is designed to coerce mortgage lenders that they need to take action. And US Bank did nothing here. And then after Omid asserted a counter—
Ms. Buck, I mean, but that actually makes me think of the other argument here about invalidity, which is that the advertisement of the sale contained what we now know was a misstatement. I mean, it's described as patently erroneous in Ms. Martinez's brief, which I think is probably a bit of an overstatement given the uncertainty in the law at the time that notice went out. But I mean, to me, the argument in your brief that the notice of the sale is more important than the advertisement of the sale, I don't get that. It seems to me that the advertisement of the sale is much more important because that's what goes out to the public. That's the one that, according to the documents in the record, was published in the Washington Post, and the one that sends the message to the world: hey, if you buy this, you have to take on this mortgage. So, I mean, why? I mean, and in Lou and in 4700 Connecticut, that was the erroneous or the misstatement about the sale being subject to the mortgage. That too was enough to send it back to the trial court. So we've got that in this case. Why isn't and that was clearly in front of the trial judge at summary judgment. Not so much in terms of the opposition to the motion for summary judgment, but in the motion for leave to amend and in the second amended complaint, which were both incorporated into the opposition to the motion for summary judgment. So why isn't that, even putting the unconscionability issue to one side, why is that enough for a remand here?
Your Honor, because the evidence of record does not demonstrate that there was any chilled bidding as a result of this misstatement in the advertisement. There's no evidence that US Bank reviewed this newspaper. There's no evidence that they relied on this statement. And in fact, the evidence that we do have of record shows that there was a competitive sale.
Isn't it obvious? I mean, why would a property that had $500,000 owed on a mortgage sell for $63,000? What other reason could there possibly be beyond that the potential buyers saw the advertisement and had a misunderstanding based on that advertisement of whether they would have to take on the mortgage?
So to first note that we have evidence of a competitive sale here. So there's no evidence that any potential investors were dissuaded from attending the sale or participating.
It's competitive among people who are operating on a misunderstanding of what they're buying.
So that's what this court essentially notes in USB or RFB, is that there is an uncertainty in the law. However, the notice of sale, and to go to your statement of our argument, is that it trumps the advertisement because it is what gives the borrowers and junior lien holders direct notice that they have a right of redemption pre-foreclosure sale, and that they can resolve this matter in its entirety by paying off the condominium lien, or at least the super priority portion. And so the notice of sale did not contain a misstatement, and it was sent directly to US Bank. And the statute also gives weight to the notice of sale in that it's required to be recorded in public land records. So that's also a form of public notice, and it has statutory requirements. And Your Honors, the association complied with all of its statutory requirements. The ad is merely a general notice requirement. And so we would argue that the notice of sale trumps the advertisement.
What about the deed? Because didn't the deed also purport to be subject to the first mortgage?
It did, Your Honor. However, again, these misstatements do not change the fact that the law did not allow for the association to sell the property subject to the first deed of trust.
I get that. I get that. The issue is whether those misstatements provide adequate support for either a claim of unconscionability or invalidity because like a mistake of fact in the sale or mistake of law or both, or whether they those circumstances in combination with others at least supported a granting of the motion to amend the complaint so that the matter could be more fully explored. And on the motion to amend the complaint, can I ask you, it was a part of the trial court's reason for denying the motion, the leave to amend, that the trial court said, addressed the merits of the proffered amendments and said plaintiff didn't include any evidence beyond conclusory allegations to show that there is any merit in the proffered amendments. And so you agree that in assessing whether the trial court ruled correctly on that, we need to then look at the additional factual allegations and see whether they create a summary judgment type issue. Because if they do, then maybe the trial court's comment here is incorrect.
Yeah, I think that there was no misstatement of fact by the trial court or law that would constitute an abuse of discretion to overturn their finding of a denial of amendment. I think that in considering the amendment, what's most notable is that the facts of the condominium sale and both Chase Plaza, 4700 Con, and Lou were decided when US Bank initiated this complaint. And the amendment is simply essentially a recharacterization of its unconscionability defense that it raised at the onset of the case. And so through the amendment, it is essentially asking for a do-over to relitigate its case properly. And so our argument is that there was no manifest error by the trial court in denying amendment. And to go back to your first point, Your Honor, I would consider the misstatement in the advertisement as a misstatement in the law, not of fact. And this court noted in lieu that equity is not antagonistic to the law. And so this court is asking that, or US Bank is asking that the condo sale be invalidated based on this misstatement, but that would be contrary to this court's decision in lieu, in that the anti-waiver provision does not allow for the association to contract away the superiority of a super priority lien.
But that's a different issue in lieu. I mean, the court in lieu was talking about whether the lien is actually extinguished, notwithstanding the bank's effort or the condo association's effort to waive the extinguishment. But what we're talking about is whether the incorrect statement invalidated the sale. It's a different issue.
Well, within the summary judgment, we are asking that the first deed of trust be declared extinguished by virtue of the super priority lien.
No, understood. But what your opponent is asking is essentially, you're using the word redo, but what they're asking for is a redo of the foreclosure sale, where everybody understands what's actually being sold, and where therefore one might expect that the purchase price would be much higher, and therefore that the bank would end up getting, would recover more of, its the funds that it's sunk into the property. That's what they're asking for. They're not asking to have their lien priority restored to them. They just want to have a sale there where everybody understands what's going on and a price that more realistically reflects the value of the property and therefore protects their interests takes place. So I don't see the tension with lieu in what they're, I don't see how it's inconsistent with lieu, what they're asking for. They may or may not have made an adequate record to be entitled to it, but I don't see how it's inconsistent with lieu.
Well, I thought that US Bank in the beginning of its argument was essentially asking and wants to find out where the surplus funds went. But I think that US Bank can assert its own independent action against the condominium association to recover any surplus funds from the super priority sale, just as they can seek an independent action after any affirmance against the borrower for any indebtedness that has not been paid. I'm not sure if my time is up, Your Honors, because I can't see the clock in the small window, but if Your Honors have any questions, I'm happy to answer them, but thank you for your time.
Your time is up unless my colleagues have questions. We'll hear now from Ms. Martinez, and we will give her 3 minutes in rebuttal.
Thank you, Your Honors.
Thank you. I just like to touch on a couple of issues that was raised in the appellee's presentation. The first relates to the advertisement, and the second relates to the prejudice in allowing U.S. Bank to amend its complaint to bring in the condo association and hash things out once and for all. So first, with respect to the advertisement, Judge Kravitz, you're right. This is what went out into the world. It ran in the Washington Post on 3 separate dates. It is what gave notice to any potential bidders of what this sale was going to be about. The idea behind a foreclosure sale, as reflected in the RFB case, is that it's an issue of contract law. Is there a meeting of the minds? And it seems in this case, there was no meeting of the minds because the bidders were not on the same page.
You say it seems that, but that's where we run up against how the matter was presented in the trial court, because it doesn't seem that hard to figure out how you would try to prove that kind of a claim. If the argument was that the bank was lulled into inaction by the false, the legally inaccurate statement in the advertisement, notwithstanding the notice that didn't contain it, well, then the bank can allege that and put on a deposition of someone who will say that's true.
Well,
if
Your Honor,
the bank's theory, and if the bank's theory is, well, that ended up ruining the sale because bidders relied on it and they thought they were buying something that wasn't as valuable, and now we find out that, contrary to everybody's understanding, it was. Well, the bidders at the sale, I assume that's knowable, and you could present all that in a opposition to summary judgment or in a motion for a leave to amend the complaint. So there are ways of trying to actually, instead of kind of assuming that these mistakes affected the conduct of the sale, to try to provide evidence that it did. And part of the issue for me is whether it's enough to infer it or assume it, or whether it was incumbent on your client to actually present the trial judge with evidence that would support those inferences and or assumptions, however you want to label them.
Well, and that's one of the issues, Your Honor. Ms. Buck said that the notice of sale was sent to U.S. Bank, but the notice of sale, I believe, was dated December 1st, 2016. U.S. Bank didn't assume the beneficial interest in this loan until June 5th, 2017. So, we've got this issue of whether or not what was U.S. Bank aware of at the time. And so what we do know is what was sent out into the public.
Well, again, the
issue
is whether we do or don't have that notice, because if U.S. Bank wanted to argue that it wasn't aware and was lulled, then I really think it was incumbent on U.S. Bank to present the trial court with that argument and factual support for it.
I understood, Your Honor. If I may just make one more point, I believe my time is out, but with this prejudice argument, and this, I will say is not on the complaint or in the record, but I did find out that U.S. Bank is still paying the property taxes and the HOA dues on this property to this date, and has done so since 2016 or 2017. And so, when we talk about prejudice here and allowing U.S. Bank to amend its complaint so that we can hash out all of these issues, there is no prejudice to Omid.
Thank you, counsel. Unless my colleagues have any questions, we will take the case under advisement. The case is submitted, and counsel may leave the virtual courtroom.
Thank you so much.
Thank you, Your Honors.
Mr. Barnes, we see a display relating to you, but you're not appearing in it right now. Are you present?
Judge McLeese, I'll be back in 20 seconds, presumably before Mr. Barnes shows up.
I'm going to take the same 20-second break. Be right back.
Perhaps the courtroom clerk could try to contact Mr. Barnes by phone to see if there is a technical difficulty.
Yes, Judge McLeese, I'm doing that right now.
Thank you.
I'm here. I'm here.
Thank you, Mr. Barnes. If you'll hold on for a moment, we're
Sure,
in a brief
Absolutely.
recess. Thank you. I will go back in session. We'll call the third case and the final case for this morning. It is Feeling versus Prof-213-S3 Legal Title Trust number 2. It's case number 18 CV 1387, etc. And we'll hear first from Mr. Barnes.
Thank you, Your Honor. As Your Honor notes, this is a consolidated appeal growing out of foreclosure action in Superior Court and the landlord and tenant action in the landlord and tenant branch. And the issues are common. The parties are common. The one of the primary issues in both courts is a question of service on the defendants in this case.
Mr. Barnes, excuse me,
Yes.
in the civil case, the foreclosure case, doesn't the issue of service just go away by the fact that your clients not only defended, but actually filed counterclaims, thereby affirmatively submitting to the jurisdiction of the court?
Well, of course, Judge Kravitz, the defendants had to respond in a timely manner. Before I got in, I think there had been a default, but they had to respond in a timely manner. I don't know that that waives their right to challenge the service of process.
Filing
And
counterclaims? Filing
Well-
counterclaims in the exact same case doesn't submit to jurisdiction in that case?
Not in my view, Judge, because the very first defense raised in the pleadings was the issue of service of process, and I don't know that that's waivable.
Well, there's no motion to dismiss filed. Instead of a motion to dismiss, you get counterclaims, which says, I want to be in front of the court in this case. I mean, isn't that what it says?
Well, I'm not sure that's what it says, but again, Judge Kravitz, the issue of service was raised not only in Superior Court, but in landlord-tenant court. And
Focusing, Mr. Barnes, for a minute on the foreclosure case.
yes, Your Honor.
What was the issue? I know that the issue of service was raised in the answer.
Yes.
Was it raised in the opposition? There was no motion to dismiss based on it. Is that correct?
That's correct, Your Honor.
And was it raised in the opposition to summary judgment?
Well, in the opposition to summary judgment, and I should point out, Judge, if I may, that there was no opportunity for discovery. The that foreclosure court that was created in 2014 was intended to give a fair opportunity to defendants, but it really functions on an expedited basis, and that's why they have early mediation. But the summary judgment was granted without hearing, Your Honor, and in the absence of discovery and the granting of the summary judgment motion from Chambers, it's the issues are not as readily fleshed out, and that's concerning.
Well, was there, I mean, I don't see that any of what you just said would be an impediment to when you filed your, I mean, you know, when the opposition of the motion to summary judgment was filed, to including in that written filing, by the way, there's a problem with process, and here's our argument about it, and it's an impediment to granting summary judgment.
Yes, and am
I right that that no such statement was included in the written opposition to summary judgment that was filed?
I apologize, Your Honor, for interrupting. The opposition to the motion for summary judgment was responsive to the motion, and so you're correct that technically it was not in written form made a part, but it was a part of the answer that was filed, as I indicated earlier.
If we address the merits of the service of process issue, my understanding is we'd have to ask something like, was there strong evidence to contradict the service processor's affidavit? And what we have here is a sort of, does your clients ever, was it Mr. Parker? Sorry if I'm getting the name wrong. Does he ever say correct, where he does in fact live?
Well, he lives in Maryland. He says that in his sworn.
Well, no, he says he lives in Maryland. Does he ever say, here's where I'm at, I have this address? Because I thought there was evidence in the record that the address he provided, when they went to that place to try to serve him, there was somebody there who said he doesn't live here.
Well, I think what happened, Judge, is that when Mr. Feeling, the co-defendant, was served and was asked about Mr. Parker, he indicated that Mr. Parker did not live there. And in landlord-tenant court, anyway, that service on Mr. Feeling was treated as substitute service on Mr. Parker. And I think that's where the deficiency in service is, that the rules are fairly clear on how you serve folks in both those courts. And those rules weren't followed. It's just concerning that these cherished constitutional rights seem so easily discarded in this expedited time we're in when it comes to these foreclosure matters and other housing matters.
Well, Mr. Barnes, you know, I mean, the rules, as you know, are actually different in a civil case and in a landlord-tenant case in terms of service of process. I mean, I'm not going to ask you any more about the foreclosure case because I think the counterclaims are problematic for you. In the landlord-tenant case, there is a suggestion in some of the Court of Appeals case law that service by posting and mailing, which is what I understand happened here, is not appropriate if the landlord knows that the tenant actually does not live at the property. I mean, ordinarily, service by posting and mailing, though the least preferred method, is allowed because the expectation is that the person lives there and will actually get the papers. There's some suggestion in case law that if the landlord knows that the defendant doesn't live there, they can't serve by posting and mailing. But I didn't see anything in the record that suggested, any evidence in the record which suggested that the landlord somehow was on notice that the I can't remember which one, the absent owner, that the absent tenant actually lived elsewhere.
Yeah, well, as Your Honor well knows, the burden of proving proper service is on the plaintiff, and in landlord and in the landlord and tenant branch, there has to be 2 attempts at personal service before you can resort to mailing and substitute service. And there's nothing that indicates that those attempts were made, and we raised that.
That's
Certainly.
actually, I don't think that's correct. The affidavits of service show, the dates are a little bit messed up, I think, but they do clearly show multiple attempts at personal service. When I say messed up, it was somewhat hard for me to read in the copy in the record, but it shows 2 different attempts, 2 different dates and times, and then the posting, I think, was at the time of the second attempt, which is maybe unfortunately, but that's the way it tends to go in landlord-tenant court.
Yeah, I agree, Judge, and it's unfortunate, but that's my point. There was no opportunity to really explore those things. It was just accepted that the service affidavit would prevail, whereas we have the counter declaration of Mr. Parker on that question. And in foreclosure cases, and I know you didn't want to return to that, Judge, I apologize, but you need in personam jurisdiction. In personam jurisdiction, that's a stronger requirement than just the posting in landlord-tenant court.
It can be waived. I think Rule 12. I think it's Rule 12 makes that clear. It says it's a defense that is unlike other jurisdictional issues that can be waived if not raised promptly. I understand you raised it in an answer. I have one question about landlord-tenant. What is Mr. Parker's interest in the landlord-tenant case? I mean,
Well,
the trial court judge could issue an order evicting me from that property. I wouldn't care. I don't live there. Mr. Parker says he doesn't live there. What's his interest?
Well, he's co-record owner of the property, and an eviction of anybody is an eviction of everybody, I would suggest, Judge.
The eviction order is, I mean, I guess I would have to go look at it. The eviction order says anybody and everybody who happens to live here is evicted? Or does it say, Mr. Parker or Mr. Feeling, you're evicted?
Well, Mr. Parker was a party to the landlord and tenant branch case, even though he was not, even though we argue he was not properly served, he was deemed a party. And if the order applies to Mr. Feeling, it applies to Mr. Parker, I would think, Judge.
You know, my only point is Mr. Parker shouldn't care if he's evicted. He doesn't live there.
Well,
I'm probably missing something very basic, and I'm hoping you can enlighten me what it is.
I don't think you're missing it.
I think that's a good point to raise, but he does care because if Mr. Feeling evicted, then they no longer have any.
It appears we may have lost Mr. Barnes. Perhaps the courtroom clerk can reach out and let him know that he's out of touch with us.
This honorable court is now back in session.
Okay, counsel, we hold on for a moment. I just wanted to advise the parties that during the break, Judge Kravitz ended up needing to leave, and he will review the remainder of the argument on the, I guess, YouTube video record. So I want to let the parties know that, and I gather that our technical difficulties have been to a degree surmounted. And I think when we took a break, and Mr. Barnes, I think, is participating by phone now, when we ended up having to break, I think Mr. Barnes had 2 or 3 minutes left, and he was had been asked a question by Judge, I forget now, Judge Kravitz. Yes, Judge Kravitz, about whether on the statute of limitations issue, each fresh failure to pay the outstanding amount was a new default that would extend the statute of limitations. So I think that's the state of play at the time we had to take a break. So Mr. Barnes, if you want to take a crack at answering that, and if you want to save some time for rebuttal, then you might want to wrap up, and we'll give you a couple minutes in rebuttal if you feel you need them. But first, why don't you take a crack at answering Judge Kravitz's question?
Sure, Judge. I appreciate that, and I apologize if the problem was at my end, but somehow we just got cut off. I would say that there's no tolling of the statute for that reason that I'm aware of. There are various ways to toll the statute of limitations, but I don't think each default tolls the statute, and that would be my view on that, Judge, and I appreciate the opportunity to respond.
Okay, counsel, do you wish to save your remaining time for rebuttal?
Yeah, I may not use it, but yes.
Okay, thank you, counsel. We'll hear now from Mr. Cohen.
Still muted.
You're muted. You're muted, Mr. Cohen.
Okay, may it please the court, Matt Cohen for the appellates. Can you hear me now? Okay, great. Our first issue that we raised in our brief is that many of the issues that are raised by the appellants were not properly raised and preserved in the trial court below for purposes of appeal. There are 3 orders consolidated on appeal. For example, there's an order challenging the summary judgment award that my client obtained in the foreclosure case, and it's raising reasons why it believes that order was not properly entered. But those reasons were not raised, if at all. They weren't raised in the trial court until the later accounting portion of the case, and therefore we would submit that they were not properly preserved for the purposes of appeal. And we also believe that they didn't properly support many of their issues on appeal with the record from the case below. For example, the eviction proceeding, there's no record of any that contains any of the filings in the eviction proceeding. There's no record of the hearing transcripts from the hearings that went on in the eviction proceeding. And that's really the appellant's responsibility to provide this court with the record. And without having done that, there's nothing that they can point to that there was any error committed by the court below. Even assuming that these issues were properly raised, the service issue, the affidavit of service we submitted is presumed valid under DC law. The appellant's own unsupported statements don't rise to the level of clear and convincing evidence needed to rebut that affidavit of service. Like Your Honor said before, the filing of the counterclaims is voluntarily, we would submit as voluntarily submitting to the court's jurisdiction in the foreclosure case.
Let me just pause you right there, because do you make that argument anywhere in your brief? Did you make that argument anywhere below that they are submitting to the court's jurisdiction as had waived their service of process claim?
We did in response to our summary, in our reply, I believe, to the summary judgment motion that they.
I mean, that would be surprising because their opposition to summary judgment didn't mention anything about service of process. But you're saying in a reply in support of summary judgment, you said they had submitted to the court's jurisdiction?
Actually, Your Honor, I don't know. We didn't raise it in our brief. I didn't see that they didn't respond to our summary judgment motion challenging service at all. I heard Your Honor say that argument before, and I recall reading it at some point. I actually believe that we made it in the reply that we filed to their opposition to our accounting, which is way later in the case, which is really the first time that they started trying to argue service with us, other than the answer, which they didn't pursue when they responded to our summary judgment motion. With regards to the judgment order authorizing the sale, giving us summary judgment, they don't dispute that they obtained the mortgage. They don't dispute that they defaulted on the mortgage. Our position is that the statute of limitation doesn't apply to an equitable claims like the ones that we asserted for judicial foreclosure. And even if latches apply, they don't provide any evidence of prejudice from the delay. The period for latches under existing DC law would be 15 years from the date of default, which wouldn't have lapsed. The contracts were signed under seal. If any sort of limitations period did apply, it would have been extended 12 years, which would have lasted past the date the complaint was filed. With regards to the order ratifying our accounting, they don't dispute that any of the distributions listed in the accounting were correct, or that they didn't agree to pay those amounts when they signed the mortgage. With regards to the eviction case, they don't dispute that they were aware of the proceeding. They don't dispute that the property was conveyed to the purchaser who was a plaintiff in that proceeding, and they don't show any entitlement, any facts in the record that would give them any entitlement to remain in the property after the property had been conveyed. Their failure to provide a record, like I said before, is most problematic in the eviction proceeding because It appears that there were hearings that they didn't attend in which we would argue that claims were abandoned, that those hearings were scheduled, the claims that were scheduled to be heard at those hearings were abandoned. We just don't know from the record what exactly went on, other than we have affidavits of service filed, and we get a judgment for an eviction. As I said before, it's their responsibility to provide the record. It doesn't exist, so there's nothing for them to point to for this court to find that there's any reversible error that was committed. For these reasons, we're asking this court to please affirm the lower court's 3 judgments. And unless Your Honors have any additional questions, I can waive the rest of my time.
Thank you, Mr. Cohen. Mr. Barnes, we'll give you a couple minutes in rebuttal.
Thank you, Your Honor. I'll just raise one point that was not addressed by Mr. Cohen. I think we addressed the others, certainly in the brief. But the question of standing and was also raised, and the statute in the District of Columbia is very clear that you have to prove that you have the original note in order to access the court.
Mr. Barnes, can I ask you, that issue was definitely raised in the trial court.
Yes.
Was it raised in your brief in this court?
Yes, Your Honor. And so I think what the trial court relied upon was just a statement from the plaintiff that they had an original note, and we raised that in our opposition to the motion for summary judgment as a fact in dispute, and it was not addressed by the trial judge. So I think that
I'm just not seeing it. I'm looking for holder, control effing holder in your brief. I'm not pulling up anything about them not being the holder of the note.
Yeah.
But you think it's in there somewhere? I'll take another look.
Yeah.
I'm not seeing it in any of your 8 issues presented either, but I will take another look.
Okay, Your Honor, I appreciate that. Also, this is de novo review, and so you look at everything that went on in the trial court to see if there were areas of error, because it was resolved on summary judgment, a summary disposition of the case. And
Well,
again,
it would be de novo review if the issue were presented to us, but we do generally confine ourselves, barring unusual circumstances, to issues that the appellant or petitioner have raised and that the appellee or respondent has had a chance to address in the briefs in this court. And I also am having trouble, I don't know if you have your briefs ready to hand, but if there's a place where you think in any one of the briefs that you filed in these various matters in this court that raised that issue, I would be interested also in your trying to point that out. If you don't have it at hand, that's fine. But if you have it at hand and you think there's a place you want to make sure we look, I would appreciate that. Well,
yeah, I moved to come in by phone, so I don't have it right in front of me anymore, Judge. But those are the issues.
We will certainly check.
Sure, I appreciate that, Judge. And with that, I submit.
Thank you, counsel. And the case is now submitted, and that is our last argument for the day. So we will stand in recess.
Thank you, Your Honor. We're excused, right?
Hold on one moment, and the courtroom clerk will say some final magic words, and then we'll be all wrapped up.
This honorable court is now adjourned.